My Lords, good afternoon. We're still on the first of Mr. Bailey's rationality challenges, which is to the definition of capital employed. And I've shown your Lordship this morning the challenges that our experts made to the capital base that was being used as part of this benchmark and the Tribunal's reasons for concern about it. But what I now need to address is Mr. Bailey's actual arguments as to why that was irrational.
Can we ask you a point of clarification about paragraph 156?
Yes.
We just want to be clear we understand the parameters of what you're saying. Are you saying that the CAT was right or wrong in 156 to use a figure of 74 million as opposed to 3.5 million? If you're not particularly supporting that, is the gist of your argument that they were right because in fact they operated at cost plus? And so even if the logic of that paragraph doesn't add up, nonetheless they were pretty much right anyway?
It's the latter, my Lord. It's the latter. So I think what I have acknowledged is that the £74 million figure would not, in normal economic terminology, be called a capital figure or a capital base.
Because most of that's covered by the buffer provision anyway. I mean, if it's just the cost of that money as it passes through very rapidly through Flynn, the cost of holding that money was the provision for buffer.
Yes.
Or the buffer provision. So,
yes. Yes, so the attack, as I hope I showed your Lordships this morning, was actually, it was at the benchmark as a whole. And the first problem with the benchmark is that applied to a company like Flynn, it results in a very small capital base that doesn't really look anything like the actual operation because it's being driven by people, not by tangible capital assets.
But do you say they're wrong to exclude some sort of number of capital for the people?
Well, we argued that at first instance, yes. What we say here, it's necessary to localise the argument. The argument that I'm facing is that the tribunal was irrational to set aside the CMA's Rocky Whack metric. And it did that for two reasons. One, because it felt that the capital base was too small. And the other one, which I'll come on to, is because it elided the cost of capital, the price of the bank loan or whatever, with a reasonable return. So that's the point that I'm meeting. And I'm trying to show your Lordships what the tribunal's reasons were.
Just on the 74 million, what do you say specifically about that? Because they treat the CMA as having erred in failing to treat the input as 74 million as opposed to 3.5.
Yes.
What's your view on that?
Yeah, so we support the use of the 74 million in order to calculate Flynn's returns. That was always our position. The 74 million represents Flynn's total operating cost of supplying phenytoin. Now, there are at least two metrics which use that reference point.
So total operating costs.
Yeah.
That's not capital.
Yeah. No, that's the point that I hope I acknowledged at the outset, that the 74 million would not conventionally be understood as capital by an economist.
Yes, so what I've taken from this is that you accept that this CAT was wrong in 156 to categorise this as 74 million as capital employed. That's wrong.
Yes.
That you say overall they were right because they were actually conducting a costs markup exercise.
That's exactly it, my Lord. That's exactly it, my Lord. That is what happened. So may I then meet Mr. Bailey's submissions? And I think your Lordship has hit the nail on the head with the first submission, which is that the CAT wrongly tried to shoehorn what it was doing into a Rocky analysis. And I've acknowledged we wouldn't describe it as a Rocky analysis. But in substance, our submission is that where it got to was rational and was consistent with the expert evidence that was given at trial. Now, Mr. Bailey says, no, it wasn't, because it leads to double recovery. That was really his point of substance. He said, well, if you confuse capital and cost, then you're recovering things twice. And I'd like to answer that, my lords, by going to Annex 3.
Just before I'm very sorry. Can you start with the provision, the paragraphs in the judgment that we are attacking or defending, as the case may be, just so we know what our headline paragraph is.
Yes,
There was an error or not an error.
yes. Well, it's Judgment 156, which is the one we've just been discussing,
Okay.
and Judgment 1484, which gives the criticism of principle that applying capital employed in the way that the CMA does produces arbitrary results, arbitrary returns, or allowable returns, depending on.
Are you reading? So what 1484 goes on for pages.
It was the coffee shop example, my lord. It was I think it's sub 1 to 3.
Is this,
But I think that was a different, the arbitrary difference between a business that has labour costs as opposed to machine costs. But that's a different point, isn't it?
Well, no, my lord, and
That's what you include within capital.
yes, I see that, and there was a debate about that. But the overall point that our experts were putting forward in the evidence and were cross-examined on was what this showed is just that this wasn't a meaningful benchmark for a company like Flynn because you just can't capture the value of what Flynn is doing by looking at some buffer stock. That was the point that was being made.
And was that evidence deployed in support of the argument that the right analogy should have been Rolls, not Rocky?
Yes, it was. Yes. Yes, and I've mentioned we do actually have a respondent's notice point. I mean, one answer to this is you accept that what the CAT was doing should not have been given the label Rocky, but you accept that overall what it was doing was a rational response to the evidence before it. And if needed, we have our respondent's notice point that Rocky wasn't appropriate, and that would actually be consistent with where the CAT gets to. But I think that the next point for my Lord Justice Green is what the CMA is actually attacking is the way that the CAT carries this out in Annex 3, and that's why I wanted to show your Lordship Annex 3 of the judgment, because that actually is what it's doing. So can we turn that up, please, at Core Bundle 938, Electronic 1013, tab 32. This is just a random page of Annex 3. It's a long annex. It has monthly figures. There's nothing special about this figure, this particular page.
this is focal point data.
Focal product data. Yes,
Focal product data.
That's right. I just want to explain to your lordships what the tribunal was actually doing, divorced of the terminology. So if your lordships take, just for example, May 2016, see that's the second yellow bar on the page. Do your lordships have that? Page 938.
I'm looking at it from the judgment. Is there an internal page?
Yes,
number?
300.
300.
So one looks at, this is just 1 month's data, May 2016.
Yes.
And take the third column, which is the 100 milligram capsule. Again, nothing really turns on which examples you're choosing. And what your lordships see at rows A to C is essentially, well, in A and C, it's a cost stack. It's Pfizer's costs, and then the price that Pfizer charges to Flynn. And then at little d, you have the product unit cost incurred by Flynn, and that's Flynn's total cost of supplying a pack of 100 milligram capsules.
Yeah.
And then
that includes the input price.
That's right. And then at F, one has the product unit price. That's what Flynn is charging. And then at the very bottom...
So can I just ask a stupid question? I understand the product unit cost incurred by Pfizer, total volume sold by Pfizer to Flynn, Pfizer product unit cost. sorry, C is Pfizer product unit price.
It's our input price. It's what
Cost
we're
to
paying
Flynn.
Pfizer.
And then it says product unit cost incurred by Flynn.
Yes.
What's the difference as far as Flynn is concerned between C and D?
It's because Flynn incurs costs other than just what it pays to Pfizer in supplying the product.
But why is it described as product unit cost?
But it is the cost of supplying a unit of the product. It's the total cost. So at C you have what we're paying to Pfizer.
Okay, sorry. So when it says incurred by Flynn, that includes what it pays to Pfizer, but also distribution costs.
Other things.
Or something.
Other things.
So what are those costs?
Overheads.
The share of
Stuff. Share of overheads, staff costs. There were various things that went into the mix, and there were various points in the investigation where that was contentious. And for these
Direct and indirect costs are properly allocated.
Just the sum. So there's some, so there's some hundreds. Yeah, there's some allocation of common costs, overheads, all otherwise.
Exactly, my lord.
Okay,
Yes, that's right. And then what you have at row H is Flynn's profit margin of 24%. And one sees what that is the difference between Flynn's product unit price and its product unit cost. So you're looking at what's the total cost of supplying the medicine, what's its price, what's the percentage difference between the two expressed as a percentage of that cost. That's what the tribunal's doing. It's a cost markup approach. And, my lords, our overall submission, and I need to get onto the core point, which is the Rocky Whack point, is it's actually difficult to see what's so wrong with that approach, that it's irrational in the sense of being a response to the expert evidence that no reasonable tribunal could have adopted. But
why? But I'm still struggling to relate these figures. Sorry, are you saying this is a model which neither fits the Rocky model nor the Oz model?
You could do Ross from these figures. So what your lordship has is the product unit cost. And if you added those all up, you would get to £74 million.
Right.
You then have the prices. And if you go from the cost to the price, you get what's called a cost markup. And that's what this measure is. You simply say, let's say your cost is 100, your price is 125, your cost markup is 25%.
or as called here, it's just a profit margin.
Or a profit margin, exactly. You can also do it in the opposite direction. So to make my maths a bit easier, you sell something for 100 that costs you 70, your ROS is 30% there because it's 30% of sales. So you're not looking at the percentages of costs, you're looking at the percentage of sales. But they're the same two reference points. You're looking at total costs and price. So you can do the sums in both directions. So, my lord, I was just submitting that overall we submit. This was not an irrational response to the expert evidence. And the only real vice in it is that the tribunal called this, it shoehorned this into what it called a Rocky approach. And actually it's a markup on costs, that's what it is. And it's close to what our experts were proposing, because we always proposed working with the total costs figure. But the point that this graph also shows, this is the point I was trying to meet, is there is no double counting levels. What this shows is that you recover your total costs and you recover a percentage margin expressed as a percentage of those costs. You're not recovering anything twice over. My lords, I'm very conscious of time. I want to deal with the Rocky Whack point, which, if I was to put an order of priority on it, is really the critical point. But I'm conscious this is slightly dense stuff, so if your lordships have questions, I'm happy to deal with them. My lord, Rocky equals Whack. So having identified Flynn's capital base as £3.5 million, the CMA then had to identify the percentage return that Flynn was entitled to earn on that capital, and it did so at 10%. And that 10% was chosen because it was found to be Flynn's weighted average cost of capital, its WACC. Now, I'm oversimplifying here, but put very simply, that is the average interest rate that Flynn would pay if it goes to Barclays or HSBC or Santander and says, I need some working capital, I'd like to take out a loan for that, please.
Where do you get that from?
Well, it's the price that you pay for capital. It's the average price that you pay for capital.
Yeah.
You can get capital in different ways. That's why I acknowledge I'm simplifying here. You could go to the bond market, you could go to investors who put in equity, at which point there's a notional 10% figure. So
This would be the same as if you'd gone to equity investors and asked them to invest. They would expect 10%.
a 10%, exactly.
So it is, in fact, it's not. They didn't actually pay 10% to Barclays Bank
It's a notional figure.
in this case. It's the notional figure what an investor would expect to make
Yes.
by investing in this business.
Yes, and you can invest via debt or via equity.
Which is the traditional analysis of what return on capital is.
What return on capital is, yeah. So, and my lord, the striking feature of the decision is that it equated Flynn's reasonable return on capital with its cost of capital, its WACC. Meaning that on the CMA's analysis, Flynn is restricted to, number one, recovering its costs, its operating costs. Number two, paying its capital providers. So in the simple example I've given, you pay your bank loan down, you've got some working capital, you have to service that, there's a cost to that. But number three, and subject to any discretion, which I'll deal with in a minute, no more. That's the reasonable rate of return. Now, we criticised this at length at the trial on the basis that it confused Flynn's costs, i.e. its costs of doing business, keeping the lights on, attracting the capital, the working capital that it needed to run as a business, with its reasonable return. And essentially what the CMA has done is identified Flynn's break-even price. And the reason I say that is because Flynn could not sell its product at a level of return below its cost of capital, because then it wouldn't even be recovering its own costs. In the medium term, that it would just go out of business. So you can't go below the WACC as a return. You're just going to go out of business if you do. And nowhere...
Wait a minute. If the cost of capital is all borrowed funds, then you may be right in that that's a debt on its balance sheet.
Yes.
If it doesn't earn enough to pay its debt, it'll go bust.
Yes.
But if you regard it as the cost of equity or the return on its equity, that's not true. It's just paying a lesser sum to its equity investors.
Well, with respect, my lord, it is in the medium term. So the measure doesn't discriminate between different types of capital or different providers of capital. But if you're not... The theory behind this measure is that it's the minimum return that's required to attract investors to give you the capital that you need, rather than going elsewhere.
Yeah, but that's the return you offer them.
Yes.
And therefore you have to make,
Yes.
by employing that capital which you borrow from them in your business,
Yes.
an equivalent amount. Because without it, you can't, in your words, break even. Although, as my lord points out, in fact, if they're equity investors, that's the whole point.
Yes.
They venture their capital without an expectation contractual of return.
Sure.
But let's just take a loan. So, in order to attract a loan investor to make a loan, you have to offer a return.
Yes.
And you take the money, employ it in your business as capital.
Yes.
You expect a return on the deployment of the capital, which equals the amount you're going to pay to your investor. Otherwise,
Yes, you can't go below that. I think it does work in a more complicated way with the equity investors, because ultimately your investors are going to pull their money out, or you're going to need more money and nobody's going to give it to you because there's better returns available.
But if that's right, the weighted average cost of capital, which I think is the amount you've got to offer to your investors,
yes,
equals the return on the capital that you will employ in your business.
But it's the minimum return that you have to earn. Yes.
Equal as a minimum. Yeah.
Yes, we're on the same page, my lord. It's the minimum return that you have to earn.
Right.
And what we say was the unexplained leap of logic was equating that baseline figure, the very minimum that you need to earn to keep the lights on, with the reasonable rate of return, which is supposed to be a proxy for normal returns under conditions of normal competition.
Normal returns to who?
Well, to the company. To the company. I mean, the CMA says, well, you can equate.
You say that the return on capital employed by the company should ordinarily exceed the weighted average cost of capital, being the amount it's going to be paying to its investors.
Yes, I mean, I'm not going to say there could be no case ever where a normal rate of return is the WACC, the interest rate, and no more. But you're
what sort of company would that be? What about a company that's just passing a product through with administrative costs but no risk, etc., etc.?
Well, no, my overall submission is going to be that to get to the normal rate of return, you need to look at what actually happens in the market.
In the market or in relation to the company concerned?
Well, you could look at the company concerned as evidence of what is a normal rate of return for a product like this in the market under normal competition.
Reasonable rate of return for a product like this in relation to this company in its particular contractual context with its supplier, which may not be normal in the rest of the market.
Well, that would be. I don't need to say that would be an irrelevant consideration. Of course not. But what we are saying is that your lordships won't find in the 500-page decision a single piece of evidence, qualitative or quantitative, that pharmaceutical companies selling generic drugs like this sell at their cost of capital. It's an economic theory. It's a baseline. You can't go below it.
But if Flynn took no economic risk in what it was doing, which I don't think it did, as I understand it, why should it look to make a greater return on its capital than the WACC?
My lord, there's no finding that Flynn took no economic risk. I think the finding is that Flynn had limited economic risk.
What was its economic risk?
Well,
it had an inelastic demand.
Yes.
Or the product, they were supplied to a third-party wholesaler.
Yes.
They administered it through to an inelastic demand.
Yes, but we were operating.
Had an indemnity. What was the indemnity?
I think there was an indemnity in the supply agreement with Pfizer.
Yeah, what was it?
I think for manufacturing defects that place you in breach of the MA conditions.
So it took no risk in relation to the product supply.
It's not that you take no risk, my lord. So, I mean, one risk is you're sitting on however many £1 million of buffer stock for a medicine that may one day be pulled from the shelves. That's an example. Which is not, it's actually not a fanciful occurrence. Another risk, yes, my learned friend reminds me, is someone else enters the market. In this case, a company called Enrim entered the market and we lost half of our sales. So the submission I'm making is that
that would only amount, in reality, that would only amount to the buffer.
Yes, plus resources that you can't reallocate, I suppose, that you've allocated to the sale of that particular product.
Didn't the product just go straight from Pfizer to the distributors, sub-distributors, whatever they're called?
In terms of physical boxes?
Yeah.
Yes. But we were the MA holder.
Yeah.
We're not a distributor. We hold the regulatory responsibilities for the drug. And there was lots of evidence at trial as to what that involved.
Yes.
But, my lord, the point that we made at trial, and this is actually the point I opened with, that the original CAT judgment accepted, is that there was no evidence to support the proposition that a normal rate of return for a drug like phenytoin is limited to the baseline level of costing of capital and no more. So let me show your lordships, I'm conscious of time, the relevant passages of the judgment, if I may, and then I'll deal with Mr. Bailey's submissions on them. And I'm going to just run through them all, if I may, and then deal with them at the end. The first one is Judgment 165, which is at page 779, electronic 854. Some of these passages will be becoming familiar now. The tribunal says it's very difficult to understand the real basis of a reasonable rate of return of 9% beyond the bare assertion that the WACC is 9%. That is a conclusory finding which it is impossible to unpick further, and for that reason alone we would be minded to reject this finding in the decision and to allow the appeal on this ground. So that's passage number one.
So can we just analyse that for one moment? So the CATS analysis set aside its 10%, not 9%, that was the SO.
Yes.
A conclusory finding, impossible to unpick further.
Yes.
So effectively saying it's just an assertion.
Yes.
So that's the essential criticism.
Yes.
And so the answer to that, at least at one level, is, well, here's 6 paragraphs, and therefore it's wrong.
Yes, I mean, you have to see what those 6 paragraphs say. Mr. Bailey took your lordship, I think, to 2 paragraphs of the decision.
Of course, that's right.
I'll deal with them, and
yes.
I'm coming back to them. Judgment 166 says the problem is, however, more fundamental. Just like the CMA's assessment of Flynn's employed capital, the CMA's WACC looks not to the focal product and the product unit cost, but to the enterprise, and it then cites and agrees with the submission in our grounds of appeal. This was the central ground for appeal for Flynn, that the WACC does not purport to be an estimate of the real-world returns earned on a product with the characteristics of phenytoin under normal competitive conditions. And then the passage immediately underneath, the decision doesn't ask the 2 key questions. 1, what is the reasonable rate of return to the entrepreneur for selling the focal product? And 2, this is really the point we're debating, does the WACC constitute a good proxy or means of assessing the reasonable rate of return? And then, my lords, 168, which is...
Pausing there. If it was a pure pass-through with no risk, why wouldn't you equate reasonable rate of return with?
Well, one reason that I'm going to show your lordships is that there was evidence to show that's not what happens in the market. I mean, that involves holding Flynn to an absurdly low margin that nobody else is held to. I'll show you your lordships.
How many other arrangements are there like this in the market?
I don't know, my lord. I can't give evidence on that. But there was voluminous evidence.
Can you give a list, actually?
A list of
other arrangements like this in the market?
No, I couldn't personally, my lord, but there was voluminous expert evidence which identified...
It's entirely a serious question, because I suspect there aren't many like this, are there?
Well, if your lordship means supply arrangements with a high input price, there absolutely are, and there was a lot of evidence on that in trial. I'm not sure what else your lordship means by the question. If you mean generic medicines where you pay a high input price to an intermediary like Flynn, there are, and we covered that in the evidence at trial.
I think we're probably talking about an agreement which has the characteristics of this one, which is described in the factual part of the decision, which explains how the agreement came about, its motivation,
yes,
what the role of Flynn was,
yes,
what the element of risk was, whether or not you coupled to the entirely otherwise legitimate process of debranding, etc., etc.
Yes. Well, my slight concern about entering into this debate is that we had a lot of expert evidence about this. We didn't have evidence, to my lord's question, of a product that had the same supply, exactly the same supply arrangements as Pfizer and Flynn. And unless it was one of our products, frankly, nor could we. We can't see those arrangements. But with the greatest of respect, this is, at the appeal level, is not the opportunity to re-debate whether or not the WACC is in fact a good proxy for the reasonable rate of return. The challenge that I'm meeting is that the tribunal acted irrationally, having heard all of the evidence, in finding that it wasn't. My lords, I was just going to go on to judgment 168.
Just on 166, the point being made by the CAT here, isn't it? Is just it looks to the enterprise, not the focal point.
I think
that's the only point being made.
I read it, my lord, as making 2 points. Sorry, at 166, your lordship is right. 165 makes a different point, and then 166 says the problem is, however, more fundamental, which shows us
165 is the bare assertion point.
Yes.
166 is you're looking at the wrong target, you're looking at the enterprise, not the focal product.
Yes, that's right. That's right. And then judgment 168, which is 781 electronic 856, puts the point up slightly more softly, I would submit. It says, the decision fails properly to address the manner in which the reasonable rate of return should be calculated. The appropriateness of WACC as a measure for this return is not considered. And then at 170, this is the conclusory paragraph I've shown your lordships.
It says, understand, when it says return to the enterprise, capital E, what is that?
What's that, sorry, my lord?
In the middle of 168, and indeed in the previous paragraph you showed us,
yes,
it talks about, we consider the use of a WACC calculated by reference to the enterprise to be prima facie inappropriate because it involves consideration of the return to the enterprise.
Yes.
What's being returned to the enterprise?
I think this is the point that my Lord Justice Zacaroli picked up on, that one of the CAT's criticisms, the first criticism is there's no articulation of why the reasonable rate of return is the WACC. The second criticism is that this rate of return is not tailored to the product.
I'm sorry, I think I may be asking an even more a simpler question. WACC is weighted average cost of capital.
Yes.
And what does that actually represent in real terms? It means, as I understand it, the return which the borrowing entity needs to return to its investors.
Yes.
So when you're looking about a WACC, you're talking about a return from the entity to investors.
Yes.
That's the interest rate you'll have to give them to encourage them to invest. So when he says we consider the use of a WACC calculated by reference to the enterprise,
yes.
What's the enterprise?
Flynn.
Flynn,
yeah.
Because it goes on to be prima facie inappropriate because it involves consideration of the return to the enterprise. That's to Flynn.
Yes.
It should be the return from Flynn.
Well, I think the point that's being made is the one that my lord picked up on, which is that the CAT was troubled by the fact that this was an enterprise-wide rate of return rather than being localised in the individual product.
Okay, I was focusing on the word to rather than by. But...
Yes, I think that's the point that's being made there, my lord. And then the conclusory paragraph at 170 says, it's over the page, it's page 782, paper copies. Secondly, the return on capital by reference to the WACC does not set out a rational basis for the rate of return derived. And as I've said, that's consistent with exactly what our expert said. Now, Mr. Bailey submitted on Tuesday that this was all wrong because Flynn's assessed cost of capital, its WACC of 10%, was intended to and did approximate real-world returns and therefore had a rational basis in the decision, such that Flynn's contention to the contrary was irrational. Now, my lords, that misunderstands the point. Mr. Bailey gave your lordships a shopping list of evidence, such as Pfizer's WACC, such as a paper produced by KPMG, said to support the 10% WACC figure. So in simple terms, said to support the fact that if Flynn went to get a business loan, it would cost 10%. But the 10% figure is emphatically not an assessment of what a normal return is for a medicine like phenytoin under conditions of normal competition. And I've said that your lordships won't see any material on that in the decision, but let me show you just one piece of evidence amongst many that was before the tribunal at trial. It's summarised as our closing submissions, para 99, which is ref supplemental bundle, tab 14, page 42. Sorry, I may have a bad reference here. Let me just check. It's
Those are your closing submissions.
yes, it's para 99. I'll just get the page number.
Tab which, sorry?
Tab 14.
14.
It's page 897, electronic 897. I think this answers my Lord Justice Green's question to Ms Stratford earlier, that there was evidence of ROCI comparators before the tribunal as well as ROS comparators. And your lordships will see that our industry expert, Mr Williams, had identified 5 comparator companies. And as I said to my lords just a moment ago, there was voluminous evidence on why those companies were comparable and why the products in their portfolio were sufficiently similar to phenytoin. Your lordships will see the figures are 63% ROCI, 67% ROCI, 176% ROCI, 229% ROCI, and then one gets to Alliance PLC, 10%. Looks like the CMA's figure. Then one sees from the footnote that the explanation for that is Alliance is a PLC with huge amounts of capital sitting on its books. So suddenly one sees the distorting effects of having very little capital on your books versus having a lot of it. But I show your lordships that not because we're asking you to make a factual finding that these do or do not reflect normal levels of return on the market, but to show your lordships that this was all part of the debate before the tribunal, which resulted in its conclusion that the decision did not contain adequate justification for equating the WACC with a reasonable rate of return. And I've told your lordships that in the original CAT judgment, para 323, that is exactly the criticism that the tribunal accepted last time around as well. Now, Mr Bailey has a point that this is all misconceived because there's discretionary headroom above the reasonable rate of return. You can see that at para 20 of the reply submissions. Now, the simple point there, my lord, I'm going to really speed up out of courtesy to my learned friends. The simple point there is that one cannot just arbitrarily set a very low reasonable rate of return that isn't an approximation of normal returns on a competitive market and then say, well, it's okay, we'll just exercise our discretion and work out as an authority if you're too far above it. It's not the right approach, my lord. The reasonable rate of return is supposed to be a proxy for a normal return under normal competitive conditions. And Mr Bailey's final point of attack was that the tribunal was wrong to say that the decision just offered no justification at all for this leap between WACC and ROCI. And I think this is the point that my lord pulled me up on at the very beginning. So let me answer it, I'm afraid, at the very end. The first answer to that is that, as I've said, the judgment actually expresses itself differently in different places. Judgment 168 puts the point as the decision failing properly to address the manner in which the reasonable rate of return should be calculated. And we say that's a very difficult finding to knock down on a rationality challenge. But in any event, we stand behind the judgment on this point. We say there is nothing in the decision. It's of course difficult to prove a negative. There's nothing in the decision to justify the leap from the identification of Flynn's baseline level of return, the level of return below which it cannot go, to saying that is its reasonable rate of return. Now, the only two paragraphs that Mr. Bailey could show you on that were paras 5.274 to 5 of the decision. I think in view of the time, I'd better not pull them up. But what they say, I mean, they make the point that my Lord Justice Snowden was making, which is that Flynn has, it doesn't say no risks, it says limited commercial risks and activities. But in our submission, that doesn't justify the leap. That's not a statement that therefore a reasonable rate of return, a normal rate of return in normal competitive conditions, is the baseline below which you cannot go. That's our overall submission, my Lord. And we put that point in spades through our submissions, and the experts made it in their evidence. And of course, that was all interwoven with a lot of empirical evidence showing that just isn't a normal rate of return in this market, even for drugs similar to phenytoin. Now, my Lords, I'll finish showing you one document and then I'll sit down. It's reference supplemental bundle, tab 14, page 895. No, sorry, I've got the wrong page again. Apologies. If I may, I'll get the reference and send it to your Lordship.
Just tell us what the point is.
So the point is that Mr. Harman, the CMA's expert, was asked in cross-examination why had he assumed that the reasonable rate of return is the WACC. And he responded, and I will get your Lordship the reference because it's not fair just to make this point in the abstract. He said, and I quote, "In the world in which I operate, it is generally assumed that is the average return that companies will earn." And my Lords, that
reference was actually only one out.
Oh, was it?
I mean, that's at 896, that's electronic 896.
Oh, of course, it's in our closing submissions, yes. Thank you, my Lord. It's 896.
Paragraph 93, page 896.
That's exactly it. And in my submission, that was the vice of the CMA's approach, that they assumed as a matter of economic theory. That's what Mr. Harman said. He assumed that is the average return that companies will earn. And we say that assumption was nowhere justified. That was the point that won in the very first appeal. We won it again, and we say there's nothing irrational in the tribunal yet again endorsing that argument. My Lords, I'm way over time. I haven't said anything about 1.1 and 1.3. 1.1, Pfizer's input price. The only real point I wanted to make on that is that, as I hope is clear from this discussion, that debate doesn't really feed into this core economic issue, because everybody, we, the CMA and the tribunal, were working with Pfizer's actual input costs to calculate the reasonable rate of return. So that's not somehow an issue that permeates this particular discussion. Your Lordship has identified other parts of the judgment where it pops up, for example, in confirmation bias. But the point I want to make is it's insulated from this core rationality challenge. Ground 1.3, I'm not sure there's anything I need to say beyond what's in writing. It's a narrow point, as your Lordship says. Again, it doesn't go anywhere without winning the rationality challenge. My Lords, I'm sorry that I've gone over.
My Lords, I'm placed in a slightly difficult position.
My Lords, we are past the halfway point. It was agreed. We are well past it.
You've got 10 seconds. What's your main point?
10 seconds. My Lord, if I have 10 seconds, then can I take you to your judgment in authorities, second bundle, tab 40, paragraph 42. This was the CMA in Phenytoin I seeking to resile from its concession made below that it would in fact take into account relevant comparators before it. And as you said in your judgment, these changes in position provide relevant and significant mitigation as to whether or not Pfizer acted negligently. We do say that the rather extraordinary and rather ambulatory nature of this case goes to the heart of the question on penalty. That is, did Pfizer act negligently or intentionally? And given that your Lordship's view in 2019 was that the journey thus far went to that point, we say, standing where we are in 2026, it must be that this could never have been a case of Pfizer acting intentionally or negligently. My Lord, I will sit down with that. I have been as terse as I possibly can be. I began with half an hour. I finished with a minute. I'm very grateful for your
only person who's lived within your time.
Well, I'm very grateful, my Lord.
Just 1 second. George, just come down. If at any point we get to the stage of penalties, since no one's really had an opportunity to address us on those, we will give people an opportunity to address the issue.
I'm very grateful.
There are a number of points which have come up, the one you've addressed, but there's a number of things which could be relevant, and we may wish to identify them and allow people to address them. So no one will be prejudiced on the issue of penalties by virtue of the fact that you haven't had much time to address it today. And that goes for everybody.
I'm very grateful, my Lord. As you say, the point only arises if the decision is restored. Effectively. I'll sit down.
Good afternoon, my lords. I'll reply on unfairness. Professor Bailey will do so on excessive. Ms MacLeod is happy to answer any questions, but otherwise has nothing to add at this point. Can I start? Well, I propose to work through each of the three findings of error, three main findings of error, which I identified in opening, starting with the immaterial factors point, developed in paras 228 and 229 of the judgment. The CMA's factors are said to show that it had an ex-ante mindset which presumed unfairness whenever cost plus is exceeded. This was primarily addressed by Mr. O'Donoghue. He said that the mindset was clear from the CMA's case at trial, and he referred you to the CMA's written closing submissions, which recorded the view of the CMA's expert economist that in the long run, prices will typically trend to a level that is reflective of costs. Mr. Donoghue said that the position of the CMA's expert was obviously wrong, those were his words, and that the tribunal had so held in the judgment. Now, we were surprised by that submission. First and foremost, the tribunal did not reject the CMA expert's evidence, at least as regards generic pharmaceuticals. It expressly accepted it, and this is another of the oddities in the judgment. Could you please...
Which paragraph?
It's paragraph 224, one of the few paragraphs in the judgment which I think has yet to be visited, which is 834 of core bundle 3, 910 of EE bundle, and 196 of the internal numbering. And could you please review paragraph 2242, in particular the second sentence? So in the context of present relevance, generic pharmaceutical markets, the tribunal agreed with the CMA's expert that prices will typically trend to cost plus. You'll recall that the same conclusion was reached by the tribunal in life irony. So the position was not wrong. Moreover, whatever the tribunal may have meant when it criticised the CMA for a supposed ex-ante mindset, it cannot have been the belief that generic pharmaceutical markets typically trend to cost plus, because that is a belief the tribunal shared. Second, and in any event, a point that I think your lordship canvassed with him, his submission tilted at the position of an independent expert at trial and not the CMA's decision, which is what matters. Third, looking at the decision, it makes clear that the CMA did not regard a price above cost plus as necessarily abusive. That is clearly stated, for example, at 5.30 and 5.89. The CMA, of course, considered cost plus as a key piece of analysis. That is because it's an essential element of the United Brands framework. There was no error in doing so. The relationship between price and cost will generally be of some relevance to determining whether prices are unfair. That is the thrust of both Phenytoin I and life-irony in both the Tribunal and the Court of Appeal. But the factors considered by the CMA at the unfairness stage show that it recognised the scope for price fairly to exceed cost plus. The CMA referred to the absence of innovation, improvement, or risk-taking, because if there had been any of these, they could differentiate a product and justify an excess. It referred to the fact that capsules were long off patent and were at the third stage of the pharmaceutical life cycle, precisely because if there were a patent, that could justify prices that were well above cost plus too, as the tribunal again recognised. It considered the commercial purpose of the parties because it recognised that this might disclose some valid reason for the very large excess. And it looked at customer reactions to see what light they shed on demand-side perceptions of value. The CMA also proceeded to consider at length the comparators suggested by the parties to see what light they shed. Did they show pricing in broadly comparable circumstances under conditions of workable competition? The CMA, for the avoidance of doubt, accepts that the prices of products, including of generic pharmaceuticals, may be justified as fair at levels exceeding cost plus. Generic pharmaceuticals are typically commodity products, not differentiated products. They're little white pills off patent, and they are very far removed from the retail, landline and broadband products, the branded products at issue in Lapaterel, which Mr. O'Donoghue programmed. For such little white pills, substantial excesses above cost plus may therefore be harder to justify as fair. But that is a factual matter to consider in the light of the reasons for the high prices, the market structure and the available comparables. For present purposes, we say the CAT had no good basis to find that the decision was informed by or that it applied a presumption or that there was any predetermination. And the CAT's reasons for dismissing the CMA's factors for finding unfairness, we say, do not hold water. They proceed from that, from that assumption that there was a presumption at work. And so we say the first finding of error cannot stand. The second finding of error was the treatment of comparables. I think you already have our key points on this. First, we rely on the CAT's almost total failure to grapple with the analysis and evidence in the decision. Second, on its failure to articulate clear and rationally defensible errors. And thirdly, on its failure to explain why the errors it alleged were material in circumstances where its own ultimate assessment of the comparators aligned with the CMA's. Now, none of those points in my submission are points of appeal on the facts. It is not that the reasons could be better expressed. We are not making a semantic complaint based on particular verbal expressions. We are making a challenge based on whether the lengthy reserved judgment in this case, produced by a 3-member tribunal with the assistance of referendaires, read as a whole, meets public law standards of reasonableness. Do the reasons stack up? Are they coherent and comprehensible? Is there a clear distortion of the evidence? Did the CAT correctly construe the decision?
Can I ask you to address Mr. O'Donoghue's point about materiality? He
Yes.
says that materiality doesn't really... It's very difficult to apply materiality because in the retaken decision, the CAT looked at least benefits of that aspect from the perspective of the fictitious ultimate consumer.
Yes.
Which might therefore be different to the way in which the more generic state would view benefits.
Yes. Well, so on materiality, I think the accusation was that I was guilty of cakeism. It was said that I couldn't rely on the CAT's reasoning and conclusions contained in Part 2 of the judgment because they were tainted by procedural unfairness. I think that was an aspect of it. I'll come to this separate point that you raised. To be clear, I do not rely on the findings in Part 2 on the basis that they must be viewed as correct. That's really not a matter for this court to resolve. I rely on them to show that the tribunal's findings in the decision were vitiated by material errors and cannot be defended. Sorry, the findings that the decision was vitiated by material errors cannot be defended as reasonable in the public law sense. The CAT issued a single judgment, which must be read as a whole. Its reasoning needed to be internally consistent. It needed to make sense. It needed to explain clearly and coherently where the CMA went wrong. And in the context of a merits appeal, it needed to explain also how the errors found could affect its ultimate finding of infringement. Now, in the case of comparators and economic value, we say that it is impossible to understand why there is error at all, or if there is some error in the reasoning or some difference on the evidence, why that is material to the CMA's infringement decision. There's no good reason to read the tribunal's judgment as though there were no remade decision, simply because that decision may itself be vitiated by another procedural error. The latter part of the judgment is particularly relevant in circumstances where the earlier part of the judgment is so unclear on the question of materiality. Indeed, the earlier part of the judgment appears to reserve the question of materiality to the later part, and they cannot therefore be divorced. In the case of the tablet ASP price data, for example, when finding that the CMA erred in supposedly disregarding the data, the CAT reserves its position. It says we cannot say at this stage whether it is supportive of a finding of fairness or a contraindicator. So it sat on the fence. That is in paragraph 268. But if that is so, where is the material error? One needs to look to the later stage. That is implicit in what's being said there, which is the part 2 of the decision, part 2 of the judgment. In the case of the drug tariff, the CAT says that it should not have been excluded from all consideration, but accepts that it was relevant to the CMA to take account of pushback from customers without indicating where that leaves matters. That is at the end of paragraph 254. Again, in that case, where is the material error? The obvious answer is to look at what the CAT itself says about the weight to be afforded to the drug tariff when it comes to that at the stage of remaking the decision. For the other AEDs, the tribunal accepts that they are nothing like as close comparators and that they need treating impressionistically and with caution. Without any consideration of what the decision says, the tribunal finds an error, but again, with what consequence for the finding of infringement? We say that to understand that question, the only place left to look is part 2 of the judgment. Now, my lord, you raised, I think, I had materiality at the forefront of my mind. I think your question was somewhat adjacent to that.
It's if in fact in the retaken decision they came to conclusions by reference to a somewhat different test to that which the CMA did, namely the fictitious ultimate consumer. Does that undermine the analysis of materiality?
Well, I think in my submission, it doesn't. Whether they had the fictitious consumer in mind at an earlier stage, we cannot know. But I think the point I've just made stands. Part 2 is where the tribunal comes on to consider materiality, having parked the question as it worked through the errors repeatedly. And whatever heuristic, whatever device is used in the retaken decision is where the cat came out. And it would be artificial to ignore or disregard the subsequent inconsistent findings. They go to the overall reasonableness of the reasons expressed in the judgment taken as a whole.
I mean, it cuts both ways, doesn't it? Because it might be that the finding in the remade decision is irrational.
Yes.
Which leaves you with a very clear finding in, for example, paragraph 255, that it was wrong to ignore altogether the drug tariff price.
And I'm not attempting to engage with that underlying debate now. My point is that you cannot rationally sustain the conclusions in part 1 of the judgment, given the inconsistencies with part 2. The judgment has to be read together. Nothing's yet been set aside. It was delivered as a single judgment. And the reasons internally don't stack up.
Can we just ask for clarification as to your position? You've had people have expressed views the appellants have about procedural fairness. Can you just clarify your position as of the end of this appeal? Do you try and support the retaken decision on grounds of procedural fairness?
Well,
that wasn't your position. We understand you wanted to have your cake and eat it in your submissions.
My Lord, you saw what we said in the letter. We do see force in the points that were raised by the court. We think that there is a profound difficulty in the approach that the tribunal took generally, both in the first part.
There was a very severe prejudice to Pfizer and Flynn, who, once the decision was set aside, you go back to zero. You're starting on a new process.
Yes.
Under Schedule 8.3. Normally, when you start a new penal process, you give someone a statement of objections, or at least tell them what it is. After all, they'd won the appeal. So they were entitled to know that now they were going to lose it, and the basis for it.
Yes.
Well, I mean, from your point of view, is different.
Some care is needed in my submission, my Lord. It's not in every case that
I agree.
The remade decision will require an elaborate procedure before the tribunal.
This was they won wholesale on everything. So it's not as if you could sever out a few tiny bits which could easily be rectified. They were going to have to start again, at least if you stop at the end of their appeal, the point at which they get to, is it material? They say it's material, it's fundamental, you've been irrational, on an array of different things.
Yes.
So, by definition, they were pretty much reading the first part of the judgment, starting again. So I agree, it would always be fact and context specific. There may be circumstances where the cat can remedy something very easily without procedural fairness, but on the facts of this case, given that they won the appeal, and now they were going to be thumped, they were at least entitled to be told that and given a chance to say something.
Yes.
And you're not in the same position, but as a regulator, having to apply the law that may come out at the end of the day, again, you're entitled to know what the position is you'd lost. You needed to address them on the matters you'd lost on, so that at the end of the day there was a considered judgment.
Yes. Yes.
In a nutshell.
Yes. Yes. I mean, I see that, as I say, I think that we see the force of the point that you are raising there. We do think that the unfairness does inure to the CMA as well as to the other parties. And we also think that...
For different reasons.
For different reasons.
But you were a party.
Yes. But it lends force also in my submission. It would be odd, I think, for the appellants to succeed in that appeal and for the conclusions that are contrary to what is said in the first part of the judgment to be ignored or left out of account. That's my submission on materiality. They need to be taken into
materiality
account.
it's a bit of an odd one. I mean, looking at the judgment, we could take the view that the procedural unfairness was immaterial because they came to the same result. I think we're quite reluctant to do that if you conclude that really in a penal procedure someone's been denied a right to say anything.
Yes.
Not certain one would really want to get into materiality or to weigh it in those terms.
Yeah, I'm conscious that Ms. MacLeod has prepared to address procedural fairness, so I don't want to go too far on this. Maybe she'll have points to add. I think for present purposes, for the CMA's...
I've written down profound difficulty, force in. That suffices for my purposes.
Well...
Thank you very much.
My Lord, yes. My Lord, I think we do see the force of your point, as we said in our letter. On materiality, though, we do say that you need to take the reasons as a whole and you can't ignore parts of the judgment.
So can I just follow up on that and where it gets us? So I'm looking at 255, which is the finding against you that it was wrong to reject the drug tariff price altogether as a comparator. It was wrong to give it more meaningful weight. So that's the finding against you. You say you can't look at that in isolation. You have to look at that in connection with the fact that when the CAT came to remake the decision, they placed no weight on it. Where does that take us? You say it's irrational. Does that mean it hasn't reached a rational finding either way on this? Which means the decision can't be reinstated. It just hasn't done its job on that analysis.
I think where that leaves you is you have incoherent reasons addressing the appeal.
Which means it has to be redone.
Well, my Lord, again, with respect, I would be keen to keep my powder dry on the remedial consequences until I have seen where you come out on all of the points.
This has nothing to do with procedural fairness, this.
No. It goes to the consequences of us finding that our appeal were upheld. I understand that.
If your appeal's upheld, it doesn't automatically follow that we reinstate the decision. There's a discretion.
Yes.
We've then got to decide whether, well, we'll have to decide what approach we take to the rationality of the decision. If you have knocked out all the CAT's objections, we've got to take account of the fact there's a respondent's notice and decide whether or not those would affect the decision.
Whether you're able to deal with those.
Or able to deal with those.
Yes, or whether they're really points.
Yeah.
And further consideration on remission. I agree. I would say that you have a situation here where both the authority and the tribunal have found a grotesque mismatch, albeit in the case of the tribunal, on the basis of reasoning.
We're not expressing. We really haven't got that far.
No.
We really haven't.
Yes.
So don't read anything into the fact that we're asking you about what happens at that point.
Yes. No, indeed. Well, perhaps that it may be better to address that point if and when we get there, depending on the reasons you give for upholding or dismissing the appeal. So, otherwise, on the comparators, I don't propose to deal in detail with the factual case that Mr. Brearley sought to advance before you. My appeal doesn't turn on the underlying factual disputes. It rests on legal errors by the tribunal in articulating the basis on which the decision is set aside. And I'll therefore confine myself to a few high-level points. First, on the drug tariff, as Lord Justice Zacaroli established in discussion with Mr. Brearley, the £30 drug tariff price in 2007 was set when there was only a monopoly supplier. The DH accepted the price while noting its expectation that further price reductions would follow. But at that stage in 2007, the DH could not compare the price against any competitive benchmark. There was therefore no error in the CMA's finding that the drug tariff was not a price set in conditions of effective competition. And contrary to Ms. Stratford's submission, the evidence of what prices emerged when at least some competition arose suggests that the drug tariff point was, at that point, was well above the price that would be paid by a willing purchaser in a non-monopolised market. The Tribunal's criticisms of the CMA's reasons on the drug tariff are impossible to make sense of, and none of the counsel appearing before you have managed to do so. The Tribunal suggests that the CMA found that there was a competition law infringement by Teva, which is not the case. The Tribunal set out a quotation which contains no such finding. Mr. Brearley sought to rescue the point by reference to 6.202 of the decision, but that again makes no such finding. It refers to prices inflated by market power, and it's well established that market power is not in itself an abuse, and nor are prices necessarily abusive merely because they are elevated by reason of market power. The Tribunal then alleges that the nature of the drug tariff is mischaracterised by the CMA, but it's entirely unclear how. The Tribunal refers again to a presumption by the CMA that anything above cost plus is illegitimate, without saying where that presumption is reflected. It says that it is not satisfied that the Department of Health was induced to agree a drug tariff rate that was inconsistent with its public law responsibilities, a claim that the decision nowhere makes. It nonetheless finds that it is not relevant to make any findings about what occurred between Teva and the department, or how the drug tariff came to be agreed. But the Tribunal does at least appear to accept that the CMA was right to have regard to the pushback when Pfizer and Flynn sought to raise the price of capsules. That is in paragraph 2543 of the judgment. So Mr. O'Donoghue was wrong to suggest that the Tribunal had rejected the CMA's reasoning wholesale. The relevance of the pushback was made clear by the submissions you heard today from Pfizer's and Flynn's counsel. The claim is the drug tariff provided the parties with a measure of the value that the purchaser, the Department of Health and the NHS, ascribed to and was reasonably willing to pay for phenytoin products. Flynn said that the point was important because it goes to show how Flynn actually set its price. It cannot be right, Ms. Stratford said, to penalise Flynn for adopting a price that had been agreed with another company for another analogous product and was the only public information available. So it's an argument based on how Pfizer and Flynn themselves assessed the purchaser's perception of value and reasonable willingness to pay. And it is therefore relevant to see what reaction Pfizer and Flynn immediately received from the Department of Health when they sought to introduce the price rises by reference to the tablets drug tariff. What the evidence shows, as set out in the decision, is that the Department of Health told Flynn that it did not accept the drug tariff as an appropriate measure of value. It pointed to differences between tablets and capsules in terms of volumes supplied. It asked Flynn for costs data to show why the price rises were justified, but that was refused. The evidence also shows that Flynn passed that information back to Flynn. That is all explained in the decision, paragraphs 6.63 and 6.64, and in further detail in paragraphs 6.222 to 6.243 of the decision.
Sorry,
None of those findings are disturbed.
Sorry, I just didn't hear those paragraphs.
Apologies. I'm moving at some
Yes, I think there was a
662, 663,
663,
6222,
and then 6222 to 6243. And the findings in those paragraphs were not disturbed by the CAT. So Pfizer and Flynn were rapidly disabused of any belief that they may have held that the drug tariff was a suitable benchmark of how the purchaser, the DOH, valued tablets. They were not left in the dark, able to base themselves only on a published price agreed years previously in relation to a different product under different conditions and with different market characteristics. In the judgment, the tribunal accepts that this was a reasonable matter for the CMA to investigate and rely upon, but it doesn't say where that leaves the drug tariff as a suitable benchmark of fairness, nor does it consider or address any of the CMA's findings or what weight should be attached to them. And all the reader can do is look to see how the tribunal itself assessed the comparator in Part 2 of the judgment. And we say that the tribunal's judgment is therefore not a rational basis for finding error, let alone material error, in the decision's treatment of the drug tariff. Second, on other AEDs, it's now accepted, I think, that the tribunal was wrong to say that the CMA applied a new test. It applied the correct legal test, and the CAT's finding to the contrary was wrong in law. Otherwise, Mr. Brearley sought to re-argue the issue on the facts, taking you to two bar charts in his principal written submissions at CB1 219. Those show a variety of other AEDs, which were said to be more expensive, a number of them branded, and some patented. It was said by Mr. Brearley that the CAT CMA ignored these. Now, as a point of clarification, and in fairness to my client, one of those two charts was not before the CMA at the administrative stage at all. It was introduced for the first time on the second appeal, and on any view, the CMA cannot be faulted for not addressing that. At all events, the tribunal rightly found that the comparators should be treated with caution and should be afforded limited weight. The only conclusion it drew from them was that pricing in pharmaceutical markets was not at cost plus. It did that despite not having any cost data on which to draw. It had only data about the prices of those products. The data was also a mixture for branded and generic products. It was also a snapshot in time which didn't consider the trends in prices as competition entered the market. As a source of information...
Can I just ask you, I mean, that observation in the judgment to pharmaceutical markets is it may well be true, no idea, but it doesn't differentiate between branded and generic, nor different types of generic.
So, no, my lord.
So even if it's true, I'm not certain where that would lead one to.
And that was exactly my next point. How does that fit with the paragraph I showed to you, in which the tribunal found that prices will typically trend towards cost in generic pharmaceutical markets, the approach that was endorsed also by the tribunal in Life Irony? It's another of the mysteries, the unresolved mysteries in this judgment. Mr. O'Donoghue suggested that the tribunal had analysed each of the 4 periods in relation to tablets, but he pointed to no specific paragraphs where that is done, and we're not aware of any. The limited conclusion drawn by the tribunal from the comparators.
Sorry, just the reference to pharmaceutical markets generally, just can you give me the para number? Sorry.
Of course, I think
273.
Sorry, 273.
No, it was 2242, if you mean the paragraph I referred to earlier, in which they found that generic pharmaceutical markets tend towards cost. Is that the reference your lordship needed? 2242.
Yep.
No attempt to reconcile that finding with the conclusion subsequently drawn from the other AED data. And what does one do with it? The suggestion that pharmaceutical markets generally don't always reflect cost plus. What was the CMA supposed to do with that? You have my point that the tribunal ultimately didn't refer to it in its own analysis. And we say that none of this is a satisfactory basis for finding any error in the decision. So the tribunal's third finding of error, economic value, there were 2 limbs to this, as we understood it, in paragraph 247, 2 identified material errors. First, it was said that medical benefits of capsules were given insufficient weight. And second, the CMA didn't give separate consideration to the appellant's entitlement to price above cost plus. Now, Mr. Brearley sought to justify the tribunal's conclusions by reference to its findings on the medical evidence. He referred to paragraph 246(3) of the judgment, in which the tribunal found that in an appropriate case, capsules were medically beneficial, and where other drugs do not work, it is very effective. And he said that this showed that the tribunal was justified in finding material error in the decision. The difficulty with this submission is that the propositions relied on have never been in dispute. That can be seen from the very beginning of the judgment. I'm sorry to take you back to it. This is hard copy 647, e-bundle 723, internal page 9. This is the uncontroversial factual background section. You see at paragraph 6, the tribunal explains that the section sets out uncontroversial facts that are important to understanding the appeals, and that controversial matters are left out of this section. And then turning over page, can I ask you please to review paragraph 9 of the judgment? So we say it was always understood and agreed that phenytoin was a third-line treatment, long superseded by other newer drugs, rarely used to treat new patients, with a declining patient population as legacy users died. None of this was in dispute. The tribunal, equally, the CMA found that for those on phenytoin, it was an effective treatment. I showed you the finding in the decision, the reference for which I cannot now locate. I'll come back to that. If we then turn with paragraph 6 in place to the tribunal's findings of error in relation to the medical evidence and patient benefit, this is hard copy bundle 855, e-bundle 930, internal page 217, paragraph 246, subparagraph 3. We say that the quotation from the decision is not controverted by any of the material relied on by Mr.
Sorry, I
Flynn.
think I've gone to the wrong paragraph number.
It begins, the capsule suffered from significant limitations on internal page 217.
217.
217.
Yes.
Capsules, looking at the quotation, capsules do suffer from significant limitations and do compare poorly to other AEDs. We just saw that in paragraph 9. That is why they are now rarely prescribed, as we saw from the uncontroversial factual background. They are indeed only a third-line treatment. Reference is made at the end of the paragraph to barriers to switching patients to other treatments, arising not because of the therapeutic benefits of capsules, that demand was sustained predominantly by barriers to switching patients to other treatments, not because of the therapeutic benefits of capsules relative to other AEDs. And that was a sentence that my Lord Justice Snowden asked about during the course of argument. The tribunal interprets this as a reference to continuity of supply, but that's not, in fact, quite right. It's based on evidence in the decision, paragraph 2.48. Maybe worth just turning this up. It's hard copy bundle CB4, page 993.
Electronic.
E-bundle, page 1068.
Thank you.
You should have, I hope, 2.48. I could ask you, please, just to quickly review that. So, and you see just from the footnotes that the evidence on which this is based is partly the evidence of Matthew Walker, Pfizer's medical expert. The tribunal doesn't suggest that any of this is wrong. Indeed, it refers itself to the final point on psychological benefit in the context of continuity of supply. The tribunal doesn't refer to the finding in the decision that for patients stabilised on phenytoin, it is an effective treatment. That is paragraph 2.5 of the decision. And we say, based on the material actually set out in the judgment at 246.3, it's impossible to discern what error on the evidence the tribunal considers to have been committed by the CMA. Otherwise, in paragraph 247, we have another allegation of a presumption, and that the CMA did not separately consider the entitlement to price above cost. I think you have my submission on that. There was no presumption set out in the decision, and the circumstances in which pricing occurs above cost were considered at length in sections 6 and 7 of the decision by reference to numerous potential comparators. Moreover, the tribunal's own assessment is that there is no economic value for Flynn for precisely the same reason as the CMA gives. This is another point on which it would be wrong to disregard the material in Part 2, where there is an obvious lacuna in Part 1. Their findings in relation to economic value in Part 1 don't deal separately with Flynn and Pfizer. They don't consider whether any of their criticisms apply to Flynn. And when we come to Part 2, we find that the tribunal endorses a finding of no economic value for Flynn on exactly the same basis that the CMA found in the decision, the lack of any value added. And we say that in the light of that stark inconsistency, the finding of material error in relation to Flynn on economic value cannot be sustained. And as regards Pfizer, you've seen again that the tribunal's own findings are that limited economic value can be assigned to Pfizer's product, given that continuity of supply confers psychological benefits, but there is otherwise no substantive difference in the patient benefit provided by Pfizer's product compared to any other phenytoin product. And we do say that's not a point tainted by the heuristic, the imaginary patient. It's just a straightforward point about whether phenytoin capsules, defined as being the Pfizer product, confer any distinctive value on patients in circumstances where the reason why patients aren't switching is because of continuity of supply, which isn't a differentiator that is the product of any benefit or input or contribution by Pfizer, a point that the tribunal itself makes in, I think it was 337.
Their conclusionary statement.
Yes.
It says the mechanism for the abuse, but no benefit.
Yes, exactly. So we say that that point stands. And again, it is flatly inconsistent with what was said earlier, that there is some material error in relation to the findings on economic value. Now, Ms. Stratford disagreed with the conclusions as to what value Flynn supplied. But that is a challenge to the decisions and the tribunal's findings, which is not a matter for this court. I don't refer to the findings on a basis that this court can resolve any factual dispute about them. My point is that the tribunal's conclusion of material error is impossible to understand in the light of that finding, and so it cannot be rationally sustained. there are no clear findings as to why there was error at all, and the CAT's own later findings suggest that the errors the tribunal considered to have been made, whatever they might be, are clearly not material to the decision for either Flynn or for Pfizer. Now, my lords, you asked whether there was any indication about how the state went about evaluating economic value for products that gave rise to avoided costs. Now, for the purposes of a competition law assessment, we do say that the avoided value point is indistinguishable as a matter of law from the essential medicine point with the Tournier risk that it gives rise to. In other words, there is ransom value where there is a monopoly supplier, and one needs to be very careful of equating the price that will be willingly paid to avoid hideous consequences by the
if you
state.
stripped aspirin out of the market, you could have an uptick in heart attacks.
My lord, you have my point, yeah, and it's not.
I think our point isn't really. I mean, there does seem to be a lacuna in the guidance provided to industry when you're dealing with generic drugs and market power. SCEMEN operates on a somewhat different premise, and it's a thought that's gone through a mind whether or not the department ought to be trying to grapple with at least providing some guidance on how it prices in these cases, rather than leaving it to competition authorities.
Well, by the time it came to 2016, there's a very clear statement, which you've probably seen in the papers, in the decision, of the department's and the government's view about practices of the kind at issue in this case. It regarded them as reprehensible, and it enacted amendments to the legislative regime to address them. So the state, at least at that point, was expressing a clear view on whether it would be appropriate to allow very high pricing simply by reference to avoided cost. And the reference for your note is to decision paragraphs 2.103 to 2.104 and 2.189. I won't, if you need the bundle references, I can give them, but I imagine you're now well familiar with where documents are located in these bundles. As regards whether guidance was needed, the issue to some extent, in my submission, can be sidestepped in this case, because you do have direct evidence about the department's specific and ad hoc reaction before the prices were introduced and immediately following their introduction, where the department expressed in no uncertain terms that it did not agree with the prices, that it did not understand them or regard them as necessarily legitimate. It did not agree that the drug tariff was an appropriate comparator, and it asked for cost information. So we say, whatever the position might be, there's no way that these particular appellants can claim that they were left in the dark about how the department regarded these massive price increases for a long-off patent medicine. My lords, there was brief reference to QALY. You have the point, obviously, that the tribunal itself rejected QALY as a measure. So this is an appeal point. It's not a point that goes against my appeal. And we rest on what we say in our reply skeleton and in the decision in Annex E, which does address QALY, although at that time there was no real evidence that had been put forward by the parties as to how QALY worked. Subject to that, those are my submissions on unfairness, and I propose to hand the floor to Mr. Bailey. Yes, my lords, just briefly and for your note, the decision refers to phenytoin being effective and essential in a number of places, not only in paragraph 2.5, but also in paragraph 1.31 and 2.33. So it's a theme that runs through the decision, and it gives the lie to a suggestion that the CMA disregarded the fact that there was patient benefit to the consumers that were stabilised. That, of course, is separate from the question of whether there is economic value that inheres, as I think was canvassed in questioning.
Please, the court. I'm going to address 7 points in reply, and just to identify them for you at the outset. First, the nature of the CMA's first ground of appeal.
Give us shorthand.
That's a shorthand for addressing the point my learned friend characterised our entire first ground as an irrationality challenge.
Oh, okay.
And it's a very brief point of clarification just to make, so it'll be very short. The second point is equally short. It deals with the authorities relating to excessive, my learned friend's understanding of our case. The third is also a short point, Flynn's mathematics, £66,000 figure. Fourth, and this will be one of my main points in reply, the way in which Flynn is now reading the judgment creatively, but seeking to suggest that although the tribunal at no point in its judgment even used the words costs markup, apparently that is what it was doing, even though that is not what it was saying or finding in its judgment. The fifth point is the keeping the lights on point. This is the break-even price that is said to be objected to by Flynn. The sixth point is Flynn's comparators, and just to clarify the nature of the task that the CMA says that it needed to undertake. And the seventh point is my Lord Justice Green this morning asked the parties for any assistance that we could give in relation to the court's jurisdiction in relation to respondent notices. And there is an authority of this court from a couple of years ago, wonderfully entitled Brace Yourself, and the NHS, and I'd just like to show you one passage from that judgment that hopefully will assist the court in that respect. So, as we end with the beginning, the excessive limb, can I start by clarifying that whilst it is right, as my learned friend suggested, that part of the CMA's ground one is an irrationality challenge, the court will have seen from paragraph 55 of our principal written submissions that we also say, as part of our ground, that the tribunal manifestly misconstrued and misunderstood the CMA's decision in relation to both capital employed and the reasonable rate of return. And we also say that the tribunal failed to take into account relevant considerations, paragraph 55, subparagraph C of our principal written submissions. And we say that in those respects, the tribunal erred in law. Now, of course, what those errors in law may mean is that ultimately the tribunal ended with a rationally insupportable conclusion, but we say it's not quite right simply to package it as if all we're saying is that the tribunal's analysis was Wednesbury unreasonableness. The second point is a brief one on the authorities. It is pleasing that Flynn does not take issue with the propositions that we set out in relation to the law, but there is, of course, one takeaway that is said to be disputed, and what does the law say about the reasonable rate of return? If I may, I would like to clarify a distinction which we see being drawn in the case law, most clearly in paragraphs 566 and 567 of the Cat's judgment in La Patarelle. We say there are essentially two questions. The first question is the law on reasonable return recognises, as the Cat found, that it is legitimate for an undertaking, including a dominant undertaking, to cover its cost of capital. And as my Lord Justice Green points out in argument with my learned friend, the European Commission says precisely the same thing in its Aspen decision. So that is what the law recognises in terms of the plus and what it means. That is distinct from a second question, which is how does one measure that cost of capital? when there are, as the tribunal recognises in paragraph 567 of Le Platerel, different methods, and my Lord Lord Justice Green also in his judgment in 2020 recognised it could be Rocky or Roke, it could be Ros, it could be another method, and that turns on the circumstances and facts of this case. But of course, as my lords are well aware by now, the CMA didn't pin its colours to any particular mast. Yes, its primary methodology, with which the tribunal agreed, was a Roke methodology, but it also, as I will take you to later this afternoon, had a cross-check applying Flynn's preferred methodology of a return on sales. So we say that that is how we put the point. There is law as to what plus means, but how one then measures that plus, of course, is a matter for methodology and judgment and has to reflect the particular facts of the case. The third point is the figure that is now just free-floating by virtue of a reference in an expert report of Flynn's economist that it is said the CMA has restricted, those were the words being used by my learned friend, to earning an annual reasonable rate of return of £66,000. I say free-floating because it's not mentioned in the judgment anywhere. It's not a figure that was put forward to the CMA during the administrative procedure, but we say a couple of other things about this. It is important to be clear how this figure was arrived at. It was arrived at by Flynn's economic expert doing their own recalculation using what I might refer to as a double cost plus. So they essentially use Pfizer's input supply price using a 10% return on sales, which is not what the CMA did in its decision. As you saw, the CMA used the real-world actual supply price. But for the purposes of this figure, Flynn is using a different figure. And as my learned friend quite rightly said, there is an important consequence to that. And it is because when one comes to then recalculate capital employed, the 3.5 million, which I should hasten to emphasise, is an annual figure. And so when there's this comparison being made between 74 million and 3.5 million, that actually is apples and oranges, because the 74 million figure is a 4-year relevant period figure. The 3.5 million figure, as is very clear on the face of the decision, is an annual figure, and so therefore one has to look at that and multiply it by 4, which my maths is reasonably okay, is about 14 million. But the important consequence of Flynn's economist's approach is that the 3.5 million annual figure goes down from 3.5 million to £658,000. And then what the economist does is to apply the 10% whack to that figure. Now, we have to say that it's a bit of a sleight of hand to suggest that in any way that the CMA is restricting Flynn to those figures calculated by its economists, not referred to by the tribunal. And we do say that for all of my learned friends talking about island hopping, one has to have considerable caution before referring to and using such a figure, which the CMA has not endorsed, and nor has the tribunal. In my submission, if one wants to see how much money Flynn was making, to use its catchphrase, in the real world, using the CMA's methodology, then I would commend to the court table 5.13, which is to be found in the decision at Core, Volume 4, Tab 33, page 1164 of the hard copy, page 1239 of the electronic copy. For reasons of time, I'm not going to ask you to turn it up, but you'll see the figures.
Which is the nearest paragraph number to it?
Oh,
5.283.
5.283.
5.283. I'm very grateful.
Thank you.
So we say that that is not a figure that should be given any credence whatsoever. The fourth point is that it was suggested this morning that the tribunal's conclusions, as aberrant as they were, on capital employed, were somehow on all fours with the expert evidence that the tribunal heard during the hearing before it. Now, I'm going to resist the temptation to try and respond to my learned friend referring my Lord Justice Zacaroli to a few snippets from Flynn's expert evidence. There's no point in me trading and giving you a few snippets from Mr. Harmon's evidence. That would invite you to undertake a task which is clearly inappropriate. What I would say, my lords, is that it was clear, and indeed we had understood to be common ground, that no party put forward product unit cost as the measure of capital employed, and Flynn itself, in its written pleadings in this court, says precisely that, and that is to be found in paragraph 14, subparagraph C of its responsive submissions. And it states that unequivocally. Neither the CMA nor Flynn were arguing for that, and that's not surprising. But my Lord Justice Green has frequently invited the parties to assist the court by going to various parts of the judgment. Can I ask the court, please, to take up the judgment and just to have a look at what is recorded by the court, by the tribunal, I apologise, in the judgment about what Flynn was arguing, just so we can see why Flynn is actually right to say no one was suggesting product unit cost is a measure of capital employed. And we can pick that up in paragraph 106, which my learned friend took the court, and that is to be found in Core Bundle, Volume 3, tab 32, hard copy, page 723, and page 798 of the electronic copy. And there is a little heading, there was a failure properly to assess the risks, and there's then a quote from the Notice of Appeal, and you'll see about halfway down the quote, Robert puts the finger on their objection. Flynn's objection is that the CMA's analysis fails to take into account intangible activities, skills and risks which by their very nature cannot be quantified. And my lords heard an echo of that being put by my learned friend this morning. Now, before we look at what the judgment says about that, that has absolutely nothing to do with equating product unit cost and capital employed. But what is important to note is that the CMA analysed this argument about intangible human capital at length in the CMA's decision. Just give you the references. Paragraphs 5.243, paragraphs 5.254, which is pages 1155 to 1157 of the hard copy, 1230 to 1232 of the electronic copy. But may I just actually show the court, if I may, just one passage from the CMA's decision on this point, because the tribunal doesn't engage with this at all. This is said to be the nub of Flynn's objection, and there's a nice point that the CMA makes about labour costs. It is to be found at paragraph 5.250, which is page 1156 of the hard copy, page 1231 of the electronic copy. This is the CMA's decision. And this is part of its analysis.
Sorry, I'm just at
5.250, my lord, page 201 of the internal numbering. That's what we're using. And this is where the CMA is analysing Flynn's claim that it's all about the humanoids, it's all about the human beings that are working in its business. And of course, as my Lord Justice Snowden observed this morning, the human assets are taken into account. Of course they are, and they should be. But the CMA points out that they are taken into account as part of the cost in Cost Plus. That is where one is allocating an appropriate amount of Flynn's indirect costs. And by the way, it's £2.5 million is allocated in costs to the human assets. So it's not an insignificant sum. And so the CMA recognises that. But the other reason I wanted to draw this to your Lordship's attention is because the CMA here, in its decision, long before we see the tribunal's judgment, is pointing out the very error that we say that the tribunal makes. Because it goes on to say, that the CMA was of the view that if the criteria for recognising within capital employed had been met, so in other words, if you could capitalise the skill and expertise of Flynn's staff, as it was claimed to be, then you see a corresponding reduction to the employee cost category would be required, in brackets, to avoid double counting. But we say, of course, you don't need to do that, because there's already a very generous £2.5 million worth of employee costs in the cost element, and therefore this was not found to be capital employed in the orthodox way in which that is understood. Now, of course, as the court knows, the tribunal in its judgment, and I'll just give you the reference, paragraph 151 and footnote 247, decides that it's not necessary for it to review the careful analysis carried out by the CMA of this point. But what the tribunal, in my submission, actually goes on to do, to use another catchphrase that Flynn is fond of, is to essentially go off on a frolic of its own. With no evidence or argument from anyone, it seeks to equate product unit cost and capital employed. Now, it was suggested this morning, in response to a question from my Lord Justice Zacaroli, that this is just terminology. We're sort of draping in the wrapper of Rocky a cost markup approach. That was the thrust of my learned friend's submissions. And it was also suggested that I wouldn't demur from that. Well, I'm not sure what the CAT was thinking in the approach that was adopted. If one can be sure of anything, both sides of the court have at times struggled to discern what exactly the tribunal held and why it held that. And I would be reluctant to embrace my learned friend's invitation to speculate as to what the CAT thought it was doing. All I can go on is what the CAT said, and we don't need to turn it up, but I'll simply tell the court, paragraph 136, under the heading, the CMA's Rocky WACC calculation, it's very clear that the tribunal understood what a Rocky WACC consisted of, because that paragraph 136 is unimpeachable in terms of setting out the two inputs for the calculation. And moreover, it's very clear from the judgment that the tribunal endorses the use of that framework. It says that a number of times in the judgment. For example, in paragraph 183(1), as just one instance. At no point in the judgment does the tribunal ever suggest that what it is seeking to do is actually a cost markup approach. And in my submission, there's a good reason for that. That's not the CMA's analysis in the decision. We did not do a cost markup approach. That was not Flynn's case at the administrative stage or at trial. There is an admirably pithy statement of Flynn's case in its trial skeleton for the tribunal, which is in the reference supplementary bundle, tab 12, at page 749, paragraph 29. Flynn's case, as my learned friend fairly accepted this morning, was return on sale. And return on sales is not the same as cost markups. One is profit as a percentage of revenue, the other is profit as a percentage of costs, and they cannot be compared directly. And I'm in the fortunate position of saying, you don't have to take that from me. Flynn itself says that in paragraph 66 of its principal written submissions, which is to be found in the core bundle, tab 14, page 254 of the hard copy, 329 of the electronic copy. And on this, it is a conspicuous error to use Flynn's own words for a specialist tribunal to, as Flynn is now suggesting it has, somehow mixed up its profitability metrics, or to be saying it's applying Rocky, but apparently, without acknowledging or referring to it, it was somehow applying a cost markup approach. We just said that makes no sense whatsoever. And in fact, if anything, it makes my point. If counsel has to speculate as to what the tribunal was actually doing, it really doesn't suggest that this is a coherent or rational judgment. And I would say to my lords that one will look in vain, if one's tempted to, in the transcripts or the expert evidence for anyone recommending cost markups. There is, however, in the decision, in footnote 731, so this is in the core bundle, volume 4, tab 33, page 1107 of the hard copy, 1182 of the electronic copy, a reference to a Auxera paper analysing profitability. And I won't take up time of it now, I'll give you the reference to it, but it's the only place I could find where in that Auxera paper they discuss cost markups, and they discuss the conceptual problems of it, and they discuss the methodological problems of it, and they also distinguishing it from return on sales. That is a short couple of pages in the reference supplementary bundle, tab 75, page 1850. In my submission, if the specialised tribunal had really meant to apply cost markups, it would have squarely said so. It would have rejected the CMA's ROCI methodology. It would have rejected, as it did, Flynn's ROS methodology. This, although very skillfully and eloquently done this morning, is not a convincing way to read the judgment.
That's always the rudest thing one can say to one's
Oh my lord, I was genuine. It was very well done. I'm going to move on to my next point, and that's the break-even price, if I may. And so this is where my learned friend makes the point that, well, actually what the CMA is doing is limiting Flynn essentially to, as he put it, the price that you pay for capital, essentially servicing its loans to its banks to keep the lights on. Now, the first thing we would say in response to that is that Flynn is not restricted, and the CMA has never suggested that it's restricted to cost plus, and that it's not simply confined to the break-even price. The WACC is an average market-based return to investors, and it's a reflection of the reasonable rate of return, not a maximum that is imposed by the competition authority. And for your Lordship's reference, that is addressed in paragraphs 5.88 and 5.89 of the CMA's decision, pages 1122 of the hard copy, 1197 of the electronic copy. That's my first response. But my second response is that my Lord Justice Green, if I may say so, was exactly right to say that one has to focus on this company with this product and what they are doing. And if one wants to talk about the real world, then taking my cue from Lord Justice Green to focus on the tribunal's findings in the judgment, in my submission, it's really important that the tribunal has found not once but twice that Flynn is engaged in very limited activity. I know your Lordships have that point, so I'll just give you the references. In the original judgment, first time round, it's paragraph 346. That's in the core, volume 2, tab 30, page 525 of the hard copy, page 600 of the electronic copy. And then again, the tribunal in this decision under appeal, in paragraph 308 and 309.2, it's in the part 3 taken decision, it says that the activities and risks, I mean, basically all it does is it's a distributor. But actually, it's not even doing the distributing. It outsources that to someone else, UDG. And it doesn't really have that many risks because of the indemnities from Pfizer. Now, the reason I emphasise that point is because one has to do what the CMA did and take the reasonable rate of return and look at this company and this product and ask, is it too stingy? Is it too generous? Is it about right? And of course, there's a judgment that has to be brought to bear in that. And that's what the CMA did in paragraph 5.274 of the decision. And that isn't acknowledged at all by the tribunal. For your reference, that paragraph is at page 1161 of the hard copy of the core, page 1236 of the electronic copy. But, my lords, there is a further point to make about this, and that is that my learned friend for Flynn emphasised the risks. And the tribunal does actually address the risks in its judgment. And could I ask you, I don't think you've been taken to this, I just want to show you a passage, if I may, another passage of the judgment. It really shows one has to read it as a whole. It's paragraph 305, which is, I do apologise, it's paragraph 304, which is page 890 of the hard copy, 965 of the electronic copy, 252 of the internal judgment numbering. And you'll see here that the tribunal acknowledges Flynn's emphasis there, as indeed earlier today, on the risks inherent in its business. But my submission is, and this is a key point that has not been challenged before this court, which is that the tribunal goes on to say the costs are incidental to Flynn's business, and then this sentence, which is key. They are, we consider, fully priced into Flynn's product unit cost. Now, if there's any risks that it bears in the ordinary course of business, is covered by cost, within cost plus. This is not a reason for why one needs to, in some way, push up the WACC to a higher level. My lords, it was suggested that it's important to focus, this is my third response, on the reasonable rate of return that would exist sort of in the real world for returns for a product like phenytoin. I mean, you have my point from Tuesday. There is no product quite like phenytoin in terms of its high costs, its high volumes, in terms of its high margins. But as my Lord Justice Green observed in argument earlier today, is there any, it was Lord Justice Snowden, is there any company that has similar arrangements of the kind where Pfizer interposes Flynn, in particular for reputational reasons, so that one can make a like-for-like comparison? If you're going to look at comparator companies, if you're going to look at headline ROS figures, then surely one has to have the sort of the business model as one feature that informs that comparison. And at no point did Flynn or Mr. Williams, its industry expert, ever identify any company that had similar arrangements of this kind. We say there is nothing normal about what Pfizer and Flynn did. Indeed, that is shown by the outrage expressed by those paying for this capsule, the clinical commissioning groups at the time. You can see that outrage expressed in Annex 2 of the CMA's decision. Now, my fourth point, my lords, is that the CMA, as I alluded to earlier, did cross-check its ROCI analysis in line with the cross-checks that the Court of Appeal encouraged the responsible authority to engage in, looking at Flynn's preferred metric of ROS and carrying to 6% ROS. And that's in decision paragraph 5.498. But there is something I wanted to show, my lords, about that particular cross-check. Could I ask you, please, to take up the CMA's decision, and in particular, could I ask you to look at paragraph 5.381, because this is a nice real-world cross-check on the so-called break-even figure, keeping the lights on. So it's paragraph 5.381, it's at page 1187 of the hard copy, 1162 of the electronic copy. So we did a cross-check at 6% return on sales. And what we see here is the CMA setting out the oral evidence of one of Flynn's directors. So it's unlikely that Flynn is going to dispute what the director said. And you can see it was put to this director that at a return on sale of 5%, Phenytoin would have been the most profitable product in Flynn's portfolio in 2013 and the second most in 2014 and 2015. And then you see the exchange, and this is quite important, my submission. It's quite clear that Flynn would have sold Phenytoin if it had been able to return a 5% return on sales. That's correct, isn't it? And then there's a clarification, but he then says, probably, yeah. Then the follow-up, well, of course you would. It would have been your second most profitable product. You wouldn't look a gift horse in the mouth, would you? Well, I try not to. And we say that that is really telling, because that is telling the tribunal first time round, and the CMA relies on this, that in the real world, had Flynn earned a return on sales of 5%, 1% less than the cross-check the CMA engaged in, of course they would have carried on business at that level. That's what their director's own oral evidence in the tribunal accepted. my lords, I do see the time, and I'm very pleased to say that I've only got 2 more points to make, and I will try and make them as crisply as I can. Would it be possible, my lords, to sit for another 10 minutes?
You have to be quicker than Mr. Johnson.
I will do my best. That's a high standard to meet. My final point, if I may, on this is simply to note that my learned friend for Flynn suggested that Mr. Harman was making assumptions by reference to a snippet from a transcript. But at no point did my learned friend address the point that Mr. Harman did a bottom-up calculation of the weighted average cost of capital for the focal product. And my lords, you have that point. It's paragraph 4.16 of Mr. Harman's position paper, which is the core supplemental bundle, tab 23 at page 218. And that's so important because there again, that's where the CMA's own expert is asking exactly what the tribunal said was the correct focus. You don't focus on the enterprise, you focus on the focal product. That's what Mr. Harman did. The results were 6.4 to 10%, and the CMA's base case is a 10% weighted average cost of capital. By the way, it was also deliberately drawn to the tribunal's attention in written closings at the trial. That's paragraph 42 of our written closings in Annex 2, reference supplementary bundle, tab 16, page 1144. Well, the 6th point is that there was a question about whether or not the CMA, in any event, has adopted a WACC that doesn't reflect real-world returns. And it was suggested, in particular, that we had failed to properly analyse the various company ROS figures. You'll recall my learned friend showed you a series of companies, which of course is not the right level to look at. But there is a further piece of analysis that again has been ignored by Flynn and ignored by the tribunal, but is set out in the decision, and it is showing how the CMA was engaging with the Flynn ROS comparators to inform its ROCI analysis as well as its ROS analysis. And I would just like to show you that, if I may, and that is to be found in the decision at paragraph 5.334, which is page 1177 of the hard copy, 1252 of the electronic version. Now this is important because, as my lordships are aware, in paragraph 184 of the judgment, we're criticised, as my learned friend indicated this morning, to have failed to take into account evidence that is relevant to ROCI. And what we see, if we pick it up please, at paragraph 5.334, is you see the contention by Flynn that the CMA should assess excessiveness based on profit margins such as ROS. You see there's no reference there to cost markups. And then if we turn over the page please, you'll see the CMA's response in 5.338. And it says, right, we're going to engage with this. We have a duty to fairly evaluate each of the comparators put forward. That is what my Lord Justice Green said in paragraph 113 of the judgment. In this case, what does the CMA do? It takes the return on sales figures put forward by Flynn and calculates the return on capital for capsules. So it's using Flynn's comparators and it is then verifying what they show in terms of the risk return as part of a ROCI approach. And then what is set out, as you can see in paragraph 5.339, the various data provided by Flynn on return on sales. And then could I ask you to turn over the page, and you can see the results in table 5.14. And in my submission, the various internal return on sales from low to high, they're all explained just slightly earlier in the decision. But the key point is that whichever metric you wish to adopt, and you cast an eye at the implied average returns on capital, they're through the roof. They are so far and away above any measure, any reasonable measure, of what the weighted average cost of capital ought to be. And the CMA observes in 5.342 that they are way above any for pharmaceutical companies, or indeed Flynn itself, through the Jeffreys valuation. And to put it in concrete terms, what one is seeing here, for every £100 that Flynn invests in capital assets to supply its other products, it would get an average return of either at least £143 or at most £211 every year. And that is to be contrasted with what it was earning on phenytoin, which is some 247%. My lords, I'll make a very brief point about comparators next, and that is simply to say, picking up on a point, if I may say so, that was astutely observed by Lord Justice Zacaroli. It's been suggested by the other side that we just took a binary approach, and the tribunal seems to have had a similar view. We say we didn't just simply turn up and say thumbs up, thumbs down. It was much more sophisticated and careful and fair than that. We looked at each Flynn comparator, I showed you that on Tuesday, and then we did what the Court of Appeal insisted we do, that we fairly evaluated them. And then once we had fairly evaluated them, including the analysis I just showed you, we then either took that into account in deciding what the reasonable rate of return is, thereby giving it some weight and relevance, or if the CMA thought that the comparator was not meaningful and unreliable, then of course it gave its reasons for rejecting that. But that's not just sort of taking a binary where you're either in or you're out. That's evaluating it, engaging with it, giving reasons for its rejection. My Lord, the Chancellor, in paragraph 270 of his judgment in these proceedings, said the CMA was entitled to do that. And my Lord Justice Green, in paragraph 113 of your judgment, similarly said, you've got to evaluate them, and then there's a margin of manoeuvre about what you do and how far you go. And of course, if you don't go far enough, there's a risk the court will overturn your decision. But my submission, my strong submission, is that there is no preclusion of an authority looking, evaluating, but ultimately rejecting. Because otherwise, the consequence of the tribunal's position is, well, every comparable can never be rejected, no matter how flawed it may be. It all goes to weight, and you're not allowed to give it no weight, so you have to give it some weight. But as my Lord Justice Green observed, well, that might be an unquantifiable thing. It's very difficult to know how the methodology is meant to work. My Lords, my final point, you'll be pleased to hear, is simply to address the court in relation to the question of jurisdiction, the respondent's notice. The court will have seen that in paragraph 21 of our responsive submissions, we have set out that we do not consider the points raised by, some of the points raised by Flynn in its respondent's notice are properly ones that are seeking to uphold the order of the tribunal for different reasons. Instead, they go to the question of what happens once you have given your judgment in terms of will there be a remittal or some other outcome. Can I just simply show you the brace yourself authority, which deals with the proper law on respondent's notice. That's in the authorities bundle, tab 51, page 739 of the hard copy, 763 of the electronic copy. And just while your lordships are finding that authority, I'll just tell you essentially what it involved. Brace yourself brought a Frankovich-style damages claim against the NHS, essentially for breaching its obligations during a tender. And the judge at first instance found that the NHS had indeed made a manifest error. That was in his first judgment. But the judge then went on to find in a second judgment it wasn't sufficiently serious for the purpose of Frankovich damages. The Brace Yourself then appealed, and NHS England filed a respondent's notice contending that not only was the judge right to say it wasn't sufficiently serious, but he was also right, he was also should have rejected it because there was no manifest error. And there's just one passage to show your lordships in Lord Justice Coulson's judgment, and that is to be found in paragraph 31, after his lordship has looked at various of the authorities. You'll see that he then draws the threads together, the principles that apply. It's page 750 of the hard copy. And he makes sort of three principles. First, that under the rules, there's a clear distinction between a respondent seeking to challenge or vary the order and a respondent seeking to uphold it on different grounds, the latter which requires no permission. Secondly, the point that doesn't necessarily arise here, that there's no general prohibition against a respondent raising challenges to the judge's findings of fact in respondent's notice. And then the third principle, that the general rule is that what matters for these purposes is the court order, whether there's a challenge to it. That will not be enforced so strictly as to ignore the reality of what the respondent is trying to do. We commend those principles as being the correct ones that are relevant. And it seems in our submission that if the CMA were, hypothetically, to win on one of its grounds, and then Flynn responds by saying, aha, well that opens up the opportunity for me to argue about my comparators, which haven't been grappled with, that is not a classic respondent's notice point. It's not saying the tribunal reached the right conclusion for a different alternative reason. Rather what it is saying is that there's unfinished business. And I will respectfully adopt my learned friend Mr. Holmes' position that it would be premature for us to seek to address the court in relation to the consequences of your lordship's judgment. But it may be that the points that Flynn are raising do go to the discretion the court has as to what to do once you have reached your conclusions in that respect. But these are not points, and this particularly applies to paragraphs 111 115 of the principal written submissions that Flynn has filed. In very brief conclusion, in my respectful submission, counsel on all sides have really struggled to decipher what's meant by the judgment, especially when read as a whole. We say, respectfully, it's internally inconsistent and indeed irrational for how it uses the concept of capital employed in paragraphs 156 and 207 of the judgment. It really is, for the very first time in competition law, and a wholly unorthodox and nonsensical use of the Rocky framework. We also say that the approach to the WACC in paragraphs 164 to 166 and 207 of the judgment are ones where the tribunal just flatly has misread and misunderstood the decision, and it's failed to consider properly or fairly the evidence and the reasons the CMA gave on that issue. And so for all those reasons, and those given by my learned friends, we do say that paragraph 342 of the disposition of the judgment, subparagraph 1, cannot stand. And unless I can assist the court any further with issues of excessive, those are the CMA's
Thank you very much indeed.
I'm very grateful.
Ms McLeod, are you following in any way, shape or form?
I wasn't intending to, my lords, unless there's any questions.
Thank you very much indeed. Camille, something to say?
Well, it's not calling the sequel, you'd be glad to hear. On a more pleasant note, Professor Bailey was recommended for appointment as King's Counsel at the end of last week. And on behalf of his colleagues at the bar, we'd like to extend our warm congratulations and to wish him well.
That's very kind. I'm sure we, on behalf of the bench, would also like to convey our congratulations. It's very richly deserved. Thank you all very much indeed. You've given us more than a little bit to think about. As you've gathered, we've done quite a lot of work on this case already, but we're going to take a bit of time to think about it. We will be very conscious of the fact that there are lots of loose ends. And if we come to the point where we need assistance, we will let you know, and we'll either invite for written submissions or we will convene a further hearing. We're very conscious of the fact we haven't heard people properly on penalties. If we get there, again, we will be very conscious that we need to ensure that everybody's had a say. When you get the judgment in the normal way, it will be treated as confidential. If there are people who need to see the judgment who are not on the list, let us know. Those people will, of course, be acutely aware of the risks of disclosing the judgment in an improper way. And when you see the draft, you will be given an opportunity to make editorial changes. Thank you all very much indeed.
All rise, if